Hello and welcome. I'm Amritan Shira and you're watching Law of the Land on Raj Sabha TV. Today we bring to you Forest Amendment Bill 2012, which seeks to empower forest officers of ranger and above rank to accept compensation in place of punishment of certain violations. To discuss the issue, I have with me Mr. N.C. Saxena, Member, National Advisory Council, Mr. M.C. Mehta, Environment Lawyer, and Mr. Sanjay Upadhyay, Advocate. Now for the headlines. The proposed law enhances limit of compounding up to 10,000 rupees. The forest dwellers will now be able to pay fine in place of facing trial for small crimes. And the forest officers may have to obtain views of the Gram Sabha before exercising the power of compounding. Now, the forest officers of the rank of rangers and above will be able to convert offences into monetary fines up to 10,000 rupees. The Indian Forest Amendment Bill proposes to enhance the limit of fine from 50 rupees to 10,000 rupees for compounding of offences. The existing law limits the power of the forest officer to compound offence.
One of the issues being faced by the forest officers while implementing the forest law is that the officer is not empowered to impose fine on the citizen beyond 50 rupees if he is caught violating the forest law. As a result, most of the offenders had to be taken to court for trial, causing inconvenience to both the parties even if the offence was very small. But now this may change as the government proposes to amend the law in order to make it possible for forest officers to accept compensation in place of punishment. This is likely to benefit forest dwellers who will now be able to pay fine in place of facing trial for punishment. After the proposed amendment is approved, forest officers of the rank of ranger and above will be empowered to impose fines, ensuring speedy justice.
If you look at the history of forest legislation in this country, India is perhaps unique, where it has always had policy after the law instead of act after the policy. So if you look at the 1865 law of forests or 1878 law, based on which the 1927 law comes. The first policy came in 1894. Then we had 1927 law. The second policy came in 1952. Then we never changed the law. We got another policy in 1988. And we still haven't amended the law in accordance with the 1988 policy. Now that is the central question.
The government proposes to allow forest officers to compound offences to the extent of 10,000 rupees. The government proposes to make rank of ranger and above as the only qualification for forest officers who will be empowered to compound forest offences. The existing law qualifies officer on the basis of monthly salary that they draw. According to the Indian forest law, only officers of the rank of ranger and above who draw a salary of at least 100 rupees per month are empowered to compound offences. By removing the salary criteria, the government seeks to uncomplicate its execution.
I think it is a major amendment in terms of how people are affected by the 1927 law. The section 68 for which the amendment has been proposed has been used by forest officers also to harass people. There are genuine cases, but a large majority of cases have also been of that of harassment of people. So this is a major amendment that is proposed.
The Indian Forest Amendment Bill 2012 seeks to amend the Forest Law of 1927. The amendment seeks to empower the forest officer to compound offences instead of taking the matter to courts for prosecution. The amendment is needed to grant relief to the tribal communities and other people living in close proximity of forests from harassment or prosecution for petty offences committed, sometimes even unknowingly.
One of the shortcomings of the Indian Forest Amendment Bill is that it lacks synchronization with the other existing forest-related laws. With camera person Suresh, Aruna Thakur, Rajya Sabha TV.
The existing law prohibits certain activities, some of which are punishable with imprisonment up to 6 months or a fine of 500 rupees. These include making fresh clearances in forests and setting fire to reserve forests. such offences can be compounded by officers empowered by the state government. That's where the punch is, sir. Clearing forest, burning forest can be compounded. Conservation versus giving relief to the forest dwellers. How do you see it?
Well, according to me, this is a very minor amendment which will not make any difference in the field, because in any case, in a large number of cases, there appears to be collusion between the forest staff, sometimes even senior forest staff, and timber merchants, with the result that a lot of deforestation is taking place in the country. Now, increasing the fees of compounding up to 10,000 may be used in a few cases here and there, but the whole scenario will not change. We needed a more comprehensive forest amendment bill, which would have looked at many other clauses. In fact, as I think Sanjay had said, we need to really harmonize our laws with the policy. Now, policy says, if you look at the 1988 forest policy, it clearly says that tribals will have the first charge on forests. But this has never been implemented. We have still not changed our forest technology in order to improve the production of minor forest products. We are still highly timber oriented. We have leased out forests to paper mills in Raigada in Odisha. Yes. JKs have leased there. Ballarpur has a lease in Maharashtra, which is totally against Forest Conservation Act. So therefore, unless we look at all these scenarios and try to bring a people-oriented forest policy, which will not result in alienation of forest dwellers, but which will improve the relations of the department with the people, and which will lead to more participation and more empowerment, that is totally missing.
That's it. I'll bring in Mr. Mehta. The pointed question to you, sir, is that there is conservation activity and there is a proper IFS institute which trains officers, which UPSC recruits to conserve the forests and wildlife, right? One hand. Second, you have a conservation law which puts into place how it has to be conserved. Third, you have this amendment which completely contradicts both the training as well as the Conservation Act. Do you see the forest officer whose approach is conservationist actually trying to implement this?
No, I don't think so. It will be possible. At the same time, this is only one thing, as my friend has said, this is no way. This is no solution, actually. We need a comprehensive law on the forest conservation, actually. And now here what is happening, the 10,000 rupees, the people will go inside, then I am witness to all these things every day in the upper reaches, that where the people, they go inside, then, nobody bothers. Even, frankly, if somebody is caught, and he is so innocent, or he does not know anything about the laws, he will give some money and just get away from it. So this is not the solution. This 10,000 rupees, how many compounding will take place, in these offences will be compounded? No. Here and then at the same time, one small change has made here, but why in 33 section it has not been made, also? Because in section 33, the 500 rupees or 6 months. There, can you buy a tree in 500 rupees nowadays? So then, if you can't buy, I can go inside even, and that's fine. There is a provision or 6 months or 500 rupees. So instead of 6 months, in my view, it should have been like a life imprisonment, like 7 years, 5 years, 2 years.
One tree which is worth 5 or 10 lakhs goes for 500 rupees.
500 rupees.
So a person is now will be initiated into going ahead and felling the tree.
Yes, felling the tree.
Because now the compounding is only 500
rupees. Yeah, 500.
And the actual cost is 5 to 10 lakhs. Impact to the government.
Yes.
Sanjay, do you see the forest cover getting impacted if this law is actually implemented the way it is designed?
No, as Dr. Saxena said already, I don't think this law is really an amendment. I think you have to first understand the history of amendment itself. If you look at the Indian Forest Act of 27, it was first attempted to be amended in 1980. Then there was a comprehensive attempt in 1994. Then there was another attempt to make it almost like the Army Act in 2003. So we have to first get to the root of the issue, which is why these amendments are actually not taking place. And the answer actually lies in what's been said already, the mandate of the forest policy, which itself needs revision. We made it in 1988, I think it's 2012. A lot has changed. We have the new Forest Rights Act. We have the amendments to the Wildlife Protection Act. We have the provisions of Panchayat to extension to Scheduled Areas Act. So there has been a history of amendments in related laws. So unless you look at those,
Upgrade it.
and look at it, in a way that you can align these laws, these kind of minor amendments, to my mind, will have absolutely no impact. And I think that's the central question.
You mean the forest officer will not try and implement it?
No, I'm not saying that. What I'm saying is this is first of all limited to scheduled areas. This 50 rupees to 10,000 has been done years ago. Goa did it in 1989. Many states have amended that. So that's really not the issue.
So it's not going to have any impact?
Not really, because it is limited to scheduled areas.
Right.
It is only the view of the Gram Sabha which has to be taken before compounding.
We'll come to that. It's time for us to head into a break. When we come back, we will talk about requirements of forest officers to consult the Gram Sabha before compounding offences. Welcome back. The bill also brings up the requirement that forest officers have to obtain and record the views of the Gram Sabha before they compound an offence. This is for scheduled areas. The Parliamentary Standing Committee has approved of the proposed amendment but feels that the forest laws need comprehensive changes.
The Standing Committee observed that the insertion of clause mentioning forest officer will consult with Gram Sabha before compounding offence would not only ensure transparency in the process of compounding of offences but also lead to participation of people through Gram Sabha. This would also open an avenue for local villagers to have a much needed say in the management and protection of forests and utilization of forest resources.
See, it may happen that the Gram Sabha may point out that these forest produce, it belongs to the village community, or it has not been stolen by such and such person. In those circumstances, a person justifiably who is having some kind of forest produce will not be subjected to this kind of penalty of even imposition of 5,000 and 10,000, because for a poor people it's a big amount.
According to the recommendations of the Standing Committee, addition of a new clause making it mandatory for the forest officer in scheduled areas to record the observation of the Gram Sabha before compounding is a step in the right direction. The committee recommends that the clause should be rephrased bicategorically, providing that the forest officer should also give due consideration to such views while passing any orders. The committee apprehends that obtaining the views of Gram Sabha may unduly delay the process of compounding of offences, so the committee recommends that the government should consider the issue and find a solution. The committee recorded the apprehension also arise out of the practical difficulties faced in obtaining the views of Gram Sabha, as it is time consuming. So it recommends that the government must pay due attention to these apprehensions and try to address them before framing rules.
Essentially talking about that Gram Sabha would be consulted. But the detail when it comes in rule will be much more important, because this is, how will a forest officer consult a Gram Sabha? What consultation means? All these issues will become very, very important in how this amendment will actually be implemented on the ground.
The committee recommended that the ministry must at least amend the relevant sections of the Indian Forest Act 1927 so as to accommodate the contemporary changes. This is required due to changing socio-economic conditions, changing in forest policy and directions of the Supreme Court issued from time to time in forestry matters.
Standing Committee report says that the proposed amendments are minute in nature and therefore suggests that Indian Forest Act requires holistic change. With camera person Suresh, Aruna Thakur, Rajya Sabha TV.
The Standing Committee report says that most of the sections of the forest law enacted in 1927 have now become obsolete, so there is need for comprehensive forest legislation. The report also says that the proposed changes in the Forest Act are token in nature. My question to you, Sanjay, the implementation part of the Gram Sabha, do you see it actually happening the way it has been written? And it's going to be that easy. It was also pointed out in the earlier thing. And are you putting, does this law put too much of a burden on the forest officer to comply with certain things before actually taking action?
No, before that, I think there's another central question and a fundamental question, which is, what is the Gram Sabha? The Gram Sabha is premised on the definition of village. And in a scheduled area context and in a forest context, the village has to be first understood. And I think the question that, I think the point that Chandrabhushan was raising, that unless we know what is the unit within which this consultation happens, because today in scheduled areas, the village as it is defined legally has not been notified. So if you don't have the village, you don't have the Gram Sabha. If you don't have the Gram Sabha, no consultation can technically happen. So it is beyond the forest officer actually.
So nothing happens. So actually nothing happens.
Nothing can happen.
No forest officer will actually notify or help in the notification of a village inside the forest, because that is what he's fighting. He wants them out. My question to you is on the implementation, anything else that you would like to add in favor of either the forest dwellers or the forest officer for implementation?
The implementation actually, unless there is an enforcement of law, nothing is going to happen. Even if you make a strong law, even if it is not implemented, how can we achieve the results? So this is the situation. Since 1927, see that at that time the forest cover and today's forest cover, it is less than 7%, or even less than that.
Yeah.
There is no honest survey, after that, after 7 or 8%, whatever we see. So this is a very serious situation now, because it is going to have a serious impact on the climate. It is the whole the Himalayan range. If you just finish everything, what is going to happen?
Sir, you've been a technocrat, a bureaucrat. You've been in the the civil services, so to say, serving the people and the government. You know there are certain ways of doing certain things. Interacting with the Gram Sabha, forest officer, no one, barring the district forest officer, the DFO or the divisional DFO, has the knack or the bandwidth to engage with Gram Sabha. The others really require a whole lot of training. In view of this, if you were a forest officer, would it be possible for you to do this, or will it be more of a what you call derailing the process of compounding?
Actually, we need to understand how administrative culture has changed in the last 100 years. When this law was made, range officer was a very senior officer of the forest department, and his bona fides were never doubted. So therefore, he was given the discretion of either compounding or sending the case for prosecution, because it was felt that he would exercise this discretion in the interest of forest cover, in the interest of conservation, etc. Today, not only there has been corruption at various levels, even levels higher than the range officer, but there is no trust between the range officer and the DFO and the conservator forest, etc. That trust is totally missing. The other big change which has taken place is no one in government wants to use this discretion. You give to them a very narrowly defined order, they will carry it out. But the moment you ask someone to use his discretion, they will feel that this will be questioned and their bona fides will be doubted. So I have, as I said earlier, no forest officer, no range officer is going to use this clause. So therefore, the clause of 10,000 rupees, etc., applies to the entire forest area. If they are not going to use that for the other areas, to think that a range officer would be foolish enough to go to a Gram Sabha is totally, impractical, and we do not know. That means the lawmakers do not understand how things happen in the field. And to expect that the range officer would go to Gram Sabha, sir, we have applied, we are doing this compounding, please give us permission, give us a views.
Not going to happen.
Not going to happen.
And he's not going to stick his neck out.
He
So
will
status
just
quo
say
will prevail.
Status quo will prevail. The other thing is, as Sanjay said, that in the field today, there is a great deal of confusion about what is meant by Gram Sabha. Actually, most states think, except for Odisha and one or two other states, they all think Gram Sabha is at the level of the panchayat, not realizing that both in FRA and also in PESA, Gram Sabha is at the last level. It is a village or the hamlet. But that concept is not known to the people. So therefore, in any case, Gram Sabhas are, in their minds, means the panchayat.
So essentially one panchayat, 7-8 villages, so 7-8 Gram Sabhas.
Yes, yes.
Makes it much more difficult.
Much more difficult, yeah.
That's it.
And at the same time, it's more, as Ms. Joshi has said, this is, Saxena has said, it is really very sad situation. Now, in the countryside, what you see, that for miles earlier, it was that land was never used to be, used for any other purpose other than the agriculture, for the agricultural purposes. But now this is happening that everywhere the buildings are coming up from here to anywhere you go. Anybody is enforcing the law? There is no. So there is that the definition of Gram Sabha or even the village, is no more now.
Non-existent.
It is non-existent.
Yes, Sanjay. Last point.
One small point is regarding the contradiction of this whole process of compounding and the concept of village forest. On one hand, there is a provision which is village forest where people are supposed to manage their forest and reserve forest and other forest areas by its own rules, which has never been put in place on one hand. And the same, so it can happen that while they are managing their affairs, they can actually translate into an offence by this amendment. So that contradiction has never been addressed.
Basically a top-down thing, not a down-up.
And which was provided way back in 1878 actually.
Yes,
not
but
just
we ignored
1927, we've ignored it.
My colleague Aruna Thakur spoke to founder member Kalpavriksha Ashish Kothari and tried to get his point of view on the issue.
The bill talks about the enhancement of compensation of compounding offences from 50 to 10,000 rupees. So, are you happy with the proposed amendment?
If you increase the compounding from 50 rupees to 10,000 rupees, the intention might be good because 50 rupees in these days is nothing. But basically what it does is it enhances the chances of bribe taking and having to give bribes, because 10,000 is a very large amount.
So the bill also talks about the consultation with the Gram Sabha. So how far do you think that the proposed amendment is going to be effective?
As far as the Gram Sabha consultation, it's a good intention. That should actually be that the Gram Sabha voice needs to be taken on board and Gram Sabha consent for any, because after all the Gram Sabhas are now supposed to be in a decentralization era, they are supposed to be the basic units of governance.
Is there any your personal suggestion for improvement in the proposed amendments?
Now, for instance, where the Gram Sabhas are taking charge, like for instance in many parts of Gadchiroli in Maharashtra or parts of Begachak in Madhya Pradesh and all, the communities are now taking charge. So they are setting their own kinds of penalties, which could be either social sanctions or boycotts or financial penalties and so on and so forth. So that kind of decision needs to be left to a decentralized body. You can have some sort of a framework in which you say that very serious offences need to be dealt with in a different way, etc. But where the forest department still remains in some kind of a control, etc., the offences which are really serious, for instance poaching of wild animals, or cutting down an entire forest or burning an entire forest, those certainly the penalties need to be increased. But again, you need a democratic framework within which those penalties can be imposed, rather than a single sort of mono control by a single department.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.